All right, good afternoon. I'm Judge Thomasis. It is 1:15, December 6, 2023. We are here in the matter of Preston and Hales, 38-2023 DR 416. If I can just have Ms. Preston as the petitioner, if you can just announce your presence for the record, state your full name.
I'm Lynette Preston.
Okay, thank you. You may be seated. Counsel?
Good afternoon, Judge. Randy Shockett, Shockett Law Group, Trenton, Florida, on behalf of the respondent.
Sir, announce your presence.
Jeremy Hales.
Okay, ma'am?
Martha Risk.
And are you co-counsel to Mr. Shockett?
No.
Okay, and then what is your purpose in being here?
Your Honor, she's in addition to being a witness, she's also one of the persons protected by the order in Ohio that we ask you to take judicial
So
notice
what
of.
would be the relevance of her being protected? She can, if she feels like she's placing herself too close to the petitioner in this case and is at risk, she should sit in the back of the courtroom. If she's a witness, she should not be sitting at counsel table.
Okay, well then you can, that's fine. Just sit right back here, please.
So we're here on several matters. The first thing I want to confirm here, hang on a second, let me pull up the case. All right, so we're here pursuant to several matters of process. On November 29, an evidentiary hearing, an adjudicatory hearing was scheduled on the petitioner's affidavit, supplemental affidavit in support of petition for injunction for protection against stalking filed October 30th, along with the initial petition for injunction for protection against stalking filed September 7. The case proceeded to hearing on November 29, at which time it became apparent to this court at or about 4:45 p.m. that the petitioner was not yet concluded in her presentation of her case in chief. The case involved and included video footage, documentary evidence, and lengthy testimony of a pro se litigant that was not completed, and certainly in consideration of allowing the petitioner to conclude presentation of her case, and likewise providing the respondent and his counsel at that time opportunity to be heard in opposition, including but not limited to cross-examination of the petitioner and presentation of evidence, either in the form of testimony and or other physical evidence, which could include videos, photographs, and according to counsel for the respondent at the time, at least 2 witnesses that were identified as being present in the courtroom. Bottom line is, it became apparent to this court that there was no way the case was going to conclude by the close of business, and the court expressed, and that record will reflect concerns for court officials and not wanting to cut the matter short. As a result of that, the court made inquiry and announced that the court would in fact clear the court's calendar for the following morning, November 30 at 9 a.m. to conclude these proceedings, balancing the need to adjudicate the case on its merits, the concerns and issues of the petitioner, the fact that there was no temporary injunction in place at the time, the need for the respondent to get a resolution which at times, which was inexplicable, characterized by his counsel at the time of, "Judge, this will just take a few minutes," when at the same time, talking out of the other side of his mouth, he had 2 witnesses at least. He had a desire to cross-examine the petitioner. He raised issues of Judge, does it matter to you? I think it was like a rhetorical question, or I don't know that he wanted it to be adjudicated, but nonetheless, the court did not. Judge, does it make any difference that the petition was not even sworn to? Which I said, yeah, all legal issues, all factual matters are important to the court if they need to be adjudicated. So I don't know what that meant, but nonetheless, the petition from September 7, 2023, which is at issue, was sworn to before a deputy clerk of court. The supplemental petition filed October 30th, 2023, was sworn to before a deputy clerk of court. The petitioner herself on November 29 at 3:09:32 seconds was sworn by the court. And so, once again, inexplicably, I don't know what he was talking about, but it became moot. Doesn't mean that it's not relevant or remains moot, but it's in that context that, and Mr. Shockett, you weren't here, but counsel for Mr. Hales at the time represented, we could resolve this in minutes. And in the history of jurisprudence, I don't know of anyone that's ever cross-examined a petitioner who presented 2 hours of testimony, confronted video evidence, documentary evidence, possibly presenting his own client. The court expressed under 9615 an intent to possibly ask the respondent several questions and present 2 other witnesses, all of which would be subject to cross-examination in a matter of minutes.
Thousands of minutes, maybe.
And so, yeah, and so the relevance of the court setting this record is what we now need to address here this afternoon. On November 29, at the close of business, that Wednesday, the court offered that we will reconvene the following morning at 9 a.m. Give me just a second here. I've got so many documents, I don't know that I have that one. I'll deal with this first. So at that time, the court mentioned we'll reconvene at 9 a.m. The petitioner mentioned to the court that despite having a medical appointment for the following morning, she would change that or reschedule that appointment for the purposes of proceeding with the matters to be adjudicated that following morning. And so, not being insensitive to the fact that she would have to reschedule, the court accepted her representation. She could be here, was willing to be here, she would reschedule. When turning to the respondent and his counsel, what was represented to the court was, one, that the respondent himself, and the language was to the effect of, he had to be present in Ohio the following morning to address matters relevant to those being considered by this court, that he had a flight out and needed to be in Ohio tomorrow morning, having to address matters in Ohio related to this situation. And so that representation was made and considered by the court. In addition, counsel at that time for the respondent stated, and another thing in effect, Judge, I've got a calendar conflict for tomorrow morning. Again, this court is obligated to consider the potential impact upon continuance to the petitioner without having a temporary injunction in place. Nonetheless, the court at that time stated we would reconvene today's date, December 6, 2023 at 1 p.m. Counsel for Mr. Hales was present, did not object to scheduling it for today at 1 o'clock, agreed to schedule it for today at 1 o'clock. His assistant, who I'm familiar with, was present with him, And again, I didn't ask them this, but it would not be too presumptuous to think that the lawyer should know what his calendar is. When I suggested the next day at 9 in the morning, he didn't tell me what his calendar conflict, nor did I inquire, but he said he had one. When I said, okay, next Wednesday, 1 o'clock, no objection, actual agreement to scheduling it, his assistant, again, I don't know that she would have done this, but it wouldn't be a far stretch to think two heads thinking better than one would say, hey, you got a calendar conflict, take a peek at your calendar, or hey, take a moment, which I would have absolutely provided to him. Bottom line is, everyone was in agreement that today at 1 o'clock we'd hear this matter. Subsequent to that, at 5:56 p.m. on a Friday, Mr. Feather, then counsel for Mr. Hales, files a motion to continue. The close of business on a Friday effectively becomes Monday as a practical matter, effectively becomes 48 hours or so before the start of this hearing, and the motion to continue, and at great length, this court entered an order denying the motion to continue on December 4. That motion to continue on its face was insufficient to grant the relief being requested. Number two, made no representation or no averment or no position stated with regards to what the petitioner's position might be, or that contact was made to see if she objects or not. Did not suggest when it might be continued to, if the court did continue it, and generally failed to establish any good cause for the requested continuance. Additionally, on the 29th, at the close of the proceedings, when the court directed and suggested and got agreement from counsel that we'd be here at 1 o'clock on 12/6 to hear this matter, the court also provided an admonition to everybody, to all parties. And the court said to respondent's counsel, in the presence of his assistant, to his client, to the petitioner, the hearing will take place on 12/6 at 1 p.m. If any calendar conflict arises, you'll have a week to take care of it by rescheduling whatever matter comes up that would otherwise potentially be in conflict. I made it really clear, this takes priority. These types of cases take priority. This particular case takes priority. This is a case we already started. This is a case that could have been concluded the following morning. This is a case that the respondent and his counsel wanted the continuance. They were granted that continuance. They don't object to the continuance. They agree to the continuance, and then they're asking for another continuance. Inexplicable, without good cause, it was denied. In addition to that, the court, and Mr. Hales, you might have said one or two things, I don't know. You weren't presented yet as a witness. Your lawyer represented to this court certain things on your behalf, and I have to accept those. I didn't question those, but you may be thinking, well, now he's questioning because in the order denying the motion to continue, I further directed the respondent to present proof of travel and his appearance in court in Ohio. Because quite frankly, that became the basis of the continuance. And in part, and we're going to get to in a moment, we're now dealing with a second successive motion to continue filed by present counsel, Mr. Shockett, who's here, on different grounds. But we'll get to that in a minute. But in part, because we now have that, it becomes even that much more important that the compliance issue is addressed. And the court asked for three things in that order. And the court has not yet received compliance. The court asked for one, written documentary proof of the travel itinerary corroborating that he did travel by plane to Ohio to be present in time for a hearing on the morning of 11/30/23, and if it wasn't for a hearing, whatever, to present written documentation confirming and corroborating that he did in fact have a required court appearance in Ohio, scheduled for the morning of 11/30/23, and 3, that he attended such proceeding. What has now been provided to the court, styled as, quote, notice of compliance with court's order dated December 4, 2023, is inadequate, insufficient, and does not respond fully to the order directing proof of compliance. What has been provided appears to be a copy of a boarding pass showing a November 30th, 10 a.m. flight from Tampa to Cleveland, and a return boarding pass from Cleveland to Tampa on December 3rd. And so the first issue that we need to resolve here is whether or not Mr. Hales has provided the court with the compliance pursuant to that order. And my intent is to ask several questions to get that resolved so we can proceed with the other matters scheduled for today. Mr. Hales, if you could raise your right hand.
Your Honor, real quick, may I be heard on that, just to give you an introduction before we do this? Because I just got some information from his Ohio lawyer that I think is
Okay.
relevant. Okay, may I be heard?
Sure.
Okay, so, thank you, and I appreciate your getting me up to speed about what happened. I haven't talked to Mr. Feather, but what I understand from him, it was a misunderstanding about a hearing in court that morning. He went to his lawyer, and this is what I want to, which I just got by email from his lawyer. Him had us draft and sign affidavits which had to be notarized in Ohio, and I've got them here, which were signed in Ohio on, related to the injunction hearing in Ohio. They were signed on December 1st, 2023. May I? Should I see?
Sure.
Okay, so there's one for John Cook. Yeah. And there's one for Lynette Cook. And I just got these by email this morning from his lawyer, asking the same questions you did, Judge, about a hearing.
Can I object to this since it's not truthful?
Hang on a second. I'll get to you in just a second. Let me see what it is. Mr. Hales, if you can raise your right hand. Solemnly swear or affirm the testimony about to give in this cause will be the truth, whole truth, and nothing but the truth.
I do.
You are Jeremy Hales, the respondent in this action.
Yes.
You were present in court on November 29 when your counsel represented that you had to be in court the following morning in Ohio.
I was in court. I apologize. I was in court. My lawyer did not say verbatim I had to be in a trial in Ohio. He said that I had.
I didn't say the word trial either. If that's
Or
what you
in
heard,
court,
or if I
you might-
misspoke, it's not, I didn't say trial.
In court.
My legal counsel did not state I needed to be in court. He stated that I needed to be in Ohio to take care of things with the court.
Having to address matters in Ohio related to this situation, correct?
Correct.
So did you or did you not have a court appearance?
I did not have a court appearance, nor was it stated that I had a court appearance.
Okay. And so what was it, you had to go there to sign some documents? That's what's been presented to the court?
Yes, sir.
Okay, so the court is familiar with, because the court does this on a daily basis, sometimes dozens of times, sometimes hundreds of times a day, which is signing documents from anywhere on the planet. Why did you have to go to Ohio to sign your name to a document?
Filing for contempt of court on the civil protection orders in Ohio, my legal counsel asked if I would fly and come and notarize and file in the court system.
That's not responsive to my question. My question is, why would you have to physically be there in Ohio to sign a document that could be signed in many, many other ways without you physically being present in Ohio to sign it?
My legal counsel in Ohio said I needed to be in person to sign the documents.
Who's your legal counsel?
Eli Heller.
Eli, last name?
Heller.
Heller?
Yes.
Where is the office?
In Cuyahoga Falls, Ohio.
So you're saying your lawyer gave you advice, by the way, anything you're talking about in terms of advice of your counsel, if you're choosing to talk about, because I'm not asking you to waive any attorney-client privilege, but you're raising as a defense to your non-compliance with this court's order that your lawyer told you you had to be there to sign documents.
Yes.
Could you tell me, if you have a basis, why, from your perspective or from what you know about your need to be there, what was your need to be there, as opposed to all other forms of the ability to sign a document from literally anywhere on the planet these days?
From my understanding, notarization in person with my lawyer and then filing in the Ohio courts.
Why couldn't you use a notary here in Florida with your lawyer here in Florida?
I did not ask that question, Your Honor.
So you're unaware whether you could have done it that way?
I am unaware.
All right. Why is it not signed until December 1st?
My flight was booked prearranged for the date that you've been provided, and then the meetings were already set per date as well.
The meeting's for December 1st?
Yes, sir.
So you did not have to be in Ohio on November 30th at 9 a.m.?
So I had to be at the Tampa airport for my flight at 9 a.m. So no, I did not need to be in Ohio at 9 a.m. I needed to be at the Tampa airport at 9 a.m.
So your lawyer's representation that you need to be in Ohio tomorrow morning, that was stated to this court at or about 4:45 to 5 p.m. on 11/29. So tomorrow morning would be the a.m. of 11:30. You're stating under oath to this court you did not physically have to be there in Ohio on the morning of November 30th.
Your Honor, I had tickets pre-purchased, so to make my flight for my appearances in Ohio, there would not have, I don't believe there would have been another opportunity to actually fly into Ohio to be able to make my appearances on
Your lawyer
time.
never used those words and said, well, Judge, just to be accurate and just to be truthful and just to articulate our basis for asking for a continuance of a case that involves a petition for protection against stalking for which there's no temporary injunction, so that you have all the facts and circumstances. Let me tell you, my client doesn't have to be there tomorrow morning, but for the fact that he's already paid for a ticket that will allow him to get there the day before he has to be there to sign a document, and maybe the court at that time could have inquired of counsel. Counsel, could you tell me, just hypothetically, why would somebody have to physically be in Ohio to sign a document? Right? That never took place. And I know that because I've reviewed the hearing half a dozen times, and I was the one who was presiding over the hearing. What was represented to this court by your lawyer is that you had to be in Ohio tomorrow morning, which would have been November 30th, a.m. Having to address, having, when lawyers use that word, has to, must, shall, requirement, be in Ohio related to this situation. And what I'm now hearing is you really didn't have to be there till the next day. It may be that you really didn't have to be there at all, because all what you did was sign a document, not see a judge who required you to make a court appearance.
Judge, may I ask some questions?
In a moment, you can. Is that accurate, Mr. Hales? Is that the more accurate representation?
I think the accurate representation is there is a scheduling conflict. And on my part, a very important scheduling conflict, to be able to catch my flight, to be able to go to the sheriff's station to pick up my certified civil protection orders against Lynette Preston and John Cook, because they could not be served to anybody else. I had to be in Ohio in person at Summit County Sheriff to receive those, then to go to see my lawyer.
Why did you have to get served with something?
Because that's the way the system works. I'm served as well. She's served, he's served, I'm served.
The issue is of November 30th in the morning, you did not need to be there to be served. You did not, now we know, need to be there to sign any documents. Because it doesn't even take place till the December 1st date.
No, sir. The issue is I had a scheduled flight to be there and do not believe I could have gotten another flight to be there on time.
did you ever set your lawyer straight when he was standing in front of this court saying that you had to address matters in Ohio tomorrow morning related to this situation?
I have discussed this with my representation, yes.
He stood in court, you were standing right next to him, we're sitting right next to him, where he said nothing about it's because his flight's tomorrow and it might cost him an inconvenience. And I would have considered that. There's no doubt that I would have. It wouldn't have been a problem. I would have also inquired, like I am now, tell me how, because I don't know of any law that requires you to physically be present in another state when you can sign it here. We have plenty of notaries. You could swear before me. You could have sworn a document in court the following morning and then sent it to your lawyer up there. And I could check with your lawyer in Ohio and we'll find out whether that process could have been available to you to accommodate you and save you from going to Ohio and back to Florida. My concern is your lawyer was misrepresenting something to the court and got away with it with a continuance to today. And what's relevant about that, aside from the issues with the lawyer, is that we're now here today with another lawyer asking for another continuance, which is putting you in a jam. I've got to be concerned about your ability to present your case, because I've got to decide this case for the interests of both of you. And the lawyering is standing in the way, to some extent, of that. Now, I haven't gotten to the next motion to continue. We're going to get to it in a second. The court makes a finding that there is non-compliance with this court's order dated December 4, 2023, which included the language that there were requirements to establish proof of the travel itinerary, that he did travel by plane to Ohio in time for a hearing on the morning of 12/1, to corroborate that he did appear and that he was required to be there, when we now know that's not exactly what it was, nor would it have been if properly, truthfully represented to the court. And I'm not saying, Mr. Hales, it's all on you, but you're sitting there while your lawyer is representing to this court and misleading the court, and nothing was done to prevent it. And nonetheless, what's relevant for today is that bought you a continuance, and now you're asking for another one. And I'm going to hear from Mr. Shockett in a moment about this next continuance. So as of now, there's non-compliance with the court's prior order, based largely in part on the misrepresentations and the less than candid representations made to this tribunal on November 29 by counsel at the time, Mr. Feather. With respect to the motion that is before this court today, the context, again, is significant because the nature of this case, the nature of the pleadings, the nature of the issues that arise, the fact that it involves allegations and averments of long-term behavior, that it included the presentation of multiple videotape items of evidentiary value, documentary evidence, that there were additional witnesses, that we had a pro se petitioner who had to go first with her case in chief, that we had a petition, a supplemental petition, which were separate pleadings. Each of them were fairly lengthy. The court at the time of the hearing on November 29th also made comment to counsel, and I don't have any indication that counsel was actually aware of what the court was even talking about. Maybe he was, but that there was a statutory change in October of 2021, that since the statutory change, there's really has been no appellate court decision addressing these facts in light of the statutory change, that the case precedent prior to the statutory change that addressed a very similar fact pattern, which I mentioned to counsel, Strober versus Harris, decided January 5, 2022 by the 2nd DCA, 332 Southern 3rd, 1079, said in part, relevant part, that it reversed that court's determination that there was not a basis for a stalking injunction, and said that a crucial part of the statutory definition that the court conspicuously failed to address was the issue of posting, that's what that case was all about, publicly posted videos. And on the phrase in the statute, caused threats to be communicated, that the court in Strober at the trial court level failed to address that, and so the DCA was sending it back, and in footnote number 1 pointed out, by the way, there's been a statutory change, House Bill 921. We confine, the second DCA was saying this, we confine our analysis to the prior version because that was in effect at the time of that case, and did not comment on which version would apply upon remand. They left that issue open. Clearly, this case, this petition and supplemental petition were filed after the operative date, the effective date of the legislation that changed things, October of 2021, when the court, when the state legislature decided, and the court needs to abide by, in Florida Statute 784.048, under subsection 1D1, the definition of cyberstalk, they included language. It states, to engage in a course of conduct to communicate or cause to be communicated, and they added these words, directly or indirectly. Then it went back to the previous words, which reads as follows: words, images, or language by or through the use of electronic mail or electronic communication directed at, and then the legislature added these words, or pertaining to a specific person. And so the addition of the 6 words, directly or indirectly, and or pertaining to, clearly redefine the analysis the court must employ to evaluate these facts in light of that statutory change. And to my understanding, and that's why I brought it to the council's attention at the time, there's been no appellate court decision addressing that matter.
On the new statute?
Correct.
Okay.
So in that context, that's one of the many reasons, along with the other things I just said, that this case is a little different than your run-of-the-mill. I handled probably 5 or 6 other injunction cases in the previous hour before I got to this one, which took 2 hours and is now clearly going to take longer than that. That being said, the court already covered the fact that I granted the continuance. It's clear to this court now that it was based on less than accurate, less than truthful representations to the court of the basis being claimed for the continuance. And I again point that out because, Mr. Shockett, you're now advancing argument why it should be continued. Again, the court gave an admonition to prior counsel that if you've got a calendar conflict, deal with that conflict by changing whatever that other matter is or may be, because we're going to be here on December 6th at 1 o'clock. There's been an intervening development that certainly may require another reevaluation, and that is subsequent to receipt of the after-hours motion to continue that this court happened to see Monday morning when coming to work and addressing it. The court then receives what amounts to a second supplemental petition filed on December 4, 2023 at 1:04 p.m. by the petitioner, which did result in the temporary relief that was previously sought and denied at least 2, if not 3 other times. That being said, and counsel is aware, and Mr. Hales, I presume, is aware, but so that he is absolutely aware, I presume, because he's had now 2 lawyers represent him, that the court has to confine its analysis of a petition accepting what's being alleged as being true, and if true, does it entitle the person for relief? The hearing then is to determine, is there competent substantial evidence, which includes truthfulness, credibility questions, et cetera, to be determined. So we were partway through a case where I must have said on multiple occasions at the close of the case to Mr. Feather, I've only heard one side of the case and not even the entire side of that case. I don't want to deny, I have no intention of denying the respondent ability to present contrary evidence or contradict or confront the evidence being presented against him. And so one issue, and Mr. Shockett, I just got to ask, because there's a notice of appearance that's styled as notice of appearance as co-counsel. Then there's your motion filed 12/5/23 at 12:53 p.m., styled as an urgent motion for continuance that states under subsection 2, co-counsel Mr. Feather, so that's consistent with your notice of co-counsel, is not available on 12/6. But then it adds this phrase, more importantly, respondent wishes to have undersigned counsel represent him at the continued hearing. There's a couple ways to read that. One is, he wants you and not Mr. Feather at the continued hearing, meaning today is the continued hearing, and you're here. So one way to read this is, the respondent gets that which he wants, and which, quite frankly, from the court's perspective, he deserves, his choice of counsel here at this continued hearing. But then it's a motion to continue, so I presume that when you say continued hearing, you're saying, if I continue it to the next hearing. And so that's one issue, because it would be presumptuous without any basis to be presumptuous, that I guess the court's going to grant this continuance because we're asking for one. That would be a fallacious and strange hypothetical assumption to make without a basis, but that'd be one way to kind of look at this. But the other is, if Mr. Hales wants you at the continued hearing to the exclusion of Mr. Feather, this court will analyze this situation differently than if really you're just co-counsel to Mr. Feather. Because if you're co-counsel to him, you then have the institutional knowledge he has. It's not like we get halfway through a trial or we get to the end of the trial and then somebody says, well, I've got the financial ability and wherewithal, I'm going to go hire another lawyer and say, I'm going to continue this case. I'm going to get another lawyer to start from scratch, rebuild my case, and maybe shore it up a little bit. I mean, I don't know where there's any precedent for such process. And I don't know that necessarily that's intended, but I don't know what's intended, nor am I questioning your involvement in the case, but I got to know what your status is.
Okay, thanks, Judge. Thank you. May it please the court. My status is to continue to represent him as lead counsel in this case. That clarifies it. Here, today, if we don't finish it, whatever happens going forward, and maybe Mr. Feather withdraws, I don't know. He is at a doctor's appointment, as I understand it, in Gainesville.
Well, here's another thing, and I don't want to be insensitive about this, okay? But under the circumstances of this case, Mr. Feather didn't plead on November 29th at or about 5 p.m. He said, I can be there on December 6th at 1 o'clock. So if it was an emergency that came up from November 29 to today's date, medical intervention of necessity, et cetera, clearly the court would have waited a lot different than, oh, Judge, I've got an appointment on December 6th at 1:45 that I didn't tell you about, and it doesn't say when it was scheduled. Maybe after we scheduled this hearing, that would be ridiculously foolish to do. But I have no information to go on, and I'm not insensitive to life happening while court is happening, okay? And so if he had a medical intervention of necessity appointment, I don't know about that. I don't know that it's good cause. I ruled it was not good cause. He could have repled it. He could have asked to provide additional information. And again, his motion and yours, and we'll get to yours in a moment here, doesn't say anything about Ms. Preston's position on this. And so we've got to come here. And so I didn't deny or grant your motion. I didn't address your motion yesterday, even though I saw it yesterday, because I couldn't, because I've got to hear from the petitioner as well.
Totally understood.
And then, in your motion, so you're saying that if the relief is granted and it's continued, you're going to present as lead counsel.
That's right, Judge.
Have you considered what you would do if the continuance is denied? Are you prepared to proceed today?
As best I can, given the limits, Judge. I just got hired yesterday. I had 2 hearings this morning, working within reasonable human hours. I looked at stuff last night, but woefully unprepared because in that short a time. And also, now we do have the temporary injunction in place, so there's no prejudice.
Which I said,
Yeah.
it changes things a little bit.
Yeah,
So, have you reviewed the proceedings from November 29?
not all of them, Judge. I don't have all the materials. I've asked for a transcript. We've ordered it rush basis, so I can see the. I do have one of those AI transcripts,
Right?
but I don't trust it because I can already see some misspellings and as you know, the devil's always in the details. So I'm waiting for the official transcript to be
So-
prepared, and also the witnesses.
So here's the thing, I'm not asking you to disclose attorney-client communication. In fact, I'm specifically stating I don't intend to do that. That being said, so I can work on a presumption here, which is when Mr. Hales contacts you, or you contact him, whatever, when you guys come into contact with each other about this pending matter, 12/6 at 1 p.m., you either had to tell him, I can be prepared despite the fact I only have 25 hours notice, or you had to tell him, I could kind of try to be prepared, but I won't anyway near be as prepared as I could be or that I should be on your behalf. If I took I presume you had a conversation. I was in practice for 36 years representing people. You probably should have had a conversation. I don't want to be too presumptuous. If I get a continuance, I'll be much more prepared than I am able to do in 25 hours. And so the relevance of the question, depending on how that conversation, either Mr. Hales willfully, intentionally, purposefully hired a lawyer who he knew absolutely could not be prepared to resolve this issue today, or he hired a lawyer that he would know would not be prepared, hoping that that would be grounds to continue this, rather than go and find a lawyer who says, man, it's a short period of time, but man, I can do what I'll do, and I'll be prepared. I'll take your case. So I'm not questioning you and saying I'm not even getting into this, but I got to question the motives of Mr. Hale in gaining a continuance, because a continuance is a victory for someone who doesn't have a temporary injunction. Precluding entry of an injunction
Correct.
is in their favor, clearly.
Right.
And to the detriment of the petitioner.
But I think at some time, well, first of all, there's more that happened in the meeting that I'm not allowed to.
Well,
reveal.
I don't want you to,
Yeah.
unless you guys are willing to waive. I'm not saying that. So that's what I'm saying. You either, and I'm not saying that you were completely negligent in not telling your client, dude, you're hiring me and the hearing's 25 hours from now, how can I possibly be prepared? Or you said, I'm on the spot, I got it, I do this all the time. Whatever, it only implicates Mr. Hale's decision to retain a lawyer who now is in front of a court saying, I cannot effectively, as competent as I want to be, represent his interests. You're saying, I'll do the best I can, and I know you will, but you're not saying, I'm going to provide him effective representation. Now, there's no constitutional requirement of effective representation when it's counsel of your choice, and you knowingly hire somebody who tells you they can't be fully prepared. Or it might be that you hire somebody who can't be so that you shore up your argument to continue it.
Okay. So, first of all, we have the protection in place here of the TO. We have that. And that did come to my attention yesterday. I think it posted online like within an hour after I filed the motion. I knew that this was relevant in weighing the prejudice to both sides. And I can tell you as an officer of the court that this is not a case of just continuing counsels, and I'll be the lead counsel in this case. And so I think there's very legitimate grounds, given what we have here, with this helps tip the scales, given this lack of...
Let me ask you another question. How do you plead under subsection 4 that the petitioner will not suffer any prejudice or inconvenience as a result of a continuance? How do you?
Well, it's a brief continuance, Judge. I don't think it's going to be any prejudice, and now.
Well, what's brief? Because that's
Well,
another
that's
thing. The
when's
motion
our court?
doesn't
I'll do
ask,
this.
the motion doesn't ask for a particular period of time.
I don't have your, well, I would say as soon as you want. I mean, within reason, give me 10 days to get prepared, and we'll be here in 10
Well,
days.
you know, I've been tempted to do this in the past, not with you, but with counsel that moves for continuance but doesn't say how long, and I could have continued it from 1 o'clock to 1:30.
Oh, right, yeah.
I mean, I don't know how
Yeah.
long you need.
Yeah, right.
Right?
You want 20 days, I'll give you 20 minutes, right, yeah.
So, to say that there would be no prejudice or inconvenience, I mean, we know at a minimum the inconvenience is the petition was here on the 29th, agreed to be here on the 30th despite the fact that she would reschedule her doctor's appointment, then agreed, if it accommodates them, and Judge, you're saying we can do it on the 6th, I'll be here on the 6th, she's here on the 6th, so there's some inconvenience, and she'll have to come back again. I don't think that you filed this pleading when there was a temporary injunction in place.
I don't know, what time was it?
Your filing is at 12:53 PM.
On the 5th or the 4th?
On the 5th.
Well, this was filed on the 4th, Judge. Wasn't this order entered on the 4th? Or the 5th? I don't even know now. Let's see. Entered on the 4th. This TRO.
And so your position is that if the court has the temporary in place, there's no prejudice because she's got the protection that she's seeking temporarily.
Yeah, and you can continue there's a day, 15 days, I think, you can continue that if it gets continued. But yeah, the protections are in place.
With regards to inconvenience, why is it not inconvenient for her to have to come back?
She's won, Judge. She's won. She has her injunction.
Well, no, she's asking for a final, at the start of the
understand.
proceedings, I ask all petitioners, are you here asking for a final judgment?
Right. Which would adopt the same standards, the same restrictions against him. Just a question of how long it's for.
Well, it's not, and I guess that's going to get us to another issue, which we'll get to in a minute, which is if there's temporary injunctive relief in place, it's going to have to include additional language than the general buffer zone language.
Okay.
And we can address that here in a second, but I guess you're not able to disclose to this court whether Mr. Hales intentionally, willfully retained counsel that could not be prepared.
There were other issues we discussed. I really don't feel,
Okay.
I'd like to say it, but I can't.
Okay, if you can't, that's fine.
It's more than just that.
There's at least the appearance of manipulation of the court to continue it, to either allow continued behaviors that are intended, to allow what came out in evidence was a financial incentive to continue certain behaviors, because it came out in evidence on November 29 that Mr. Hales makes a financial profit from the actions that Ms. Preston is claiming are causing her substantial emotional distress.
And she's met that burden, which is a higher burden without evidence here. And, you know, she's
Right,
basically.
but that's, what I'm saying is, on this point, is that the continuance could be to the benefit of Mr. Hales, while it's to the detriment of Ms. Preston,
I just.
because he's earning a living.
But he's prohibited from doing the acts that cause harm,
Well,
so.
that's the part we need to be clear about.
Okay, let's
In
be
the
clear about
temporary
it.
injunction.
Yeah, Sure.
Because I don't think the temporary standard injunction that was previously ordered necessarily includes that. And let me share with you something else, Mr. Shaka, and
Okay.
again, this is, I presume, outside of your control.
Go ahead.
Which is part of what's pled in the second supplemental petition filed December 4.
I did see that supplemental petition.
Yeah, is that Hale's attorney, which is referencing Mr. Feather, has called making multiple offers of cash or proceeds from Mr. Hale's videos or telling his fans to leave me alone.
twice now.
hang on, and I say that, and ma'am, I have to accept the words that you've pled as true. We're gonna get to an evidentiary hearing
Okay.
about whether there's more or whatever, but that's what's
Okay.
pled.
Sorry.
And that's especially relevant because it was Mr. Feather, when I suggested that, hey, this can't, at 4:44, 4:47, when I said, this is not likely to finish here today, and he pushed back and I said, denied, it's being continued. There's good news and bad news. Bad news, you're gonna all have to come back. The not so bad news, I don't know if that's good, is maybe counsel for the respondent and the petitioner can communicate about working towards a resolution. And I said that in the context, and I kind of regret saying it, quite frankly, but I said it in the context of, I've presided over hundreds, maybe thousands, of these similar cases, and there are people, just like every other civil case, that can work towards a resolution. Clearly, Mr. Hales and Ms. Preston should not be the two people. And so I suggested maybe counsel can speak to, and it was Mr. Feather that said to the court, and hang on, I just quote, that the language in the Ohio injunction that was already in place would not allow for such communication, and that in fact, from his perspective, Ohio's law would consider it a violation. And I said, well, I don't understand that. I said, show me. He handed me a copy of the final judgment from Ohio. I read it, and I said, I don't see here where contact between an attorney for the respondent having communication, working towards a resolution of a potential litigation in another matter, somewhat related, but another matter, would be a violation of Ms. Preston violating the terms of that Ohio law. But that was the position taken by Mr. Feather. And I didn't absolve him of that. I didn't resolve that issue. I didn't give him any clear carte blanche. No, dude, it's cool. In fact, what I said to him is I said, if you need clarification on that so that it's not a violation from either perspective here, I'll call the judge in Ohio and we can always carve out an exception. I do it all the time with my colleagues in the criminal court. They have no contact, and then I have the same people in a divorce case. Judge, can you modify that language to allow them to attend mediation with a mediator and their lawyers present? We'll do it by Zoom. We work out those deals all the time.
But interstate, you've done it interstate as well?
Yeah.
Okay.
Feather was the one that pointed out 741 point, hang on, don't hold me to it, but 135 or whatever. I've got jurisdiction. There's full faith and credit for their order.
Yes.
He actually said, and this is another thing contradicting, and I'm saying, Mr. Hales, I'm not saying you're contradicting what I'm about to say here, but your lawyer did, which is, the lawyer was representing to me, Mr. Hales had to go up there to do something. I now know it's about dealing with some alleged violation, what have you. Feather was here in court saying, Judge, we anticipate. The word wasn't anticipate. I can pull up the exact word, but it was about we anticipate, we expect, something to that effect, don't hold me to it, I don't have the transcript in front of me, the filing of a violation here in your court for Ms. Preston allegedly violating. I go, why would you be filing that here? And he brings up the statute and says, because we can. And I didn't contradict that. Okay, if and when you do so, we'll cross that bridge when we get to it, but we're not there yet. You anticipate it, you expect to do so, whatever, you haven't done so yet.
I think they did it today, Judge. I think they did it today.
Okay, but it's Feather who says to me, this premise of speaking to Ms. Preston would be violating a court order from a judge and or magistrate in the state of Ohio. And then I get an allegation that I have to accept as true. It may not be ultimately when we get to an evidentiary hearing, but I have to accept it as true that he's contacted her and on multiple occasions offers her cash to drop this or to some way settle this. And that, on top of everything else I've already talked about exhaustively here, is very troubling. And has to be considered when we're considering continuing this thing even again. There is at least on the face of what's pled, and I know you're restricted in maybe not being able to say more, that there's a possibility that the motion to continue is manipulative at best. That being said, I've already said we could probably come up with conditions in addition to the general ones of the temporary that would satisfy this court, allow for Mr. Hales to have fully effective representation because of attaining a fully prepared lawyer, and giving Ms. Preston peace of mind between now and then, even if it's at the cost of what I consider slight, but still some measure of inconvenience of having to come back, but everybody would have to come back.
And we may not have finished today either, I don't know, Judge. We may have to wind up being here at 4:45 and witnesses and who knows, right? So,
I've considered that as well.
yeah.
I've considered that as well. So, with regards to the temporary, this is my concern. It doesn't address the specifics of cyber stalking as is alleged, and which this court has only heard really the one side and not even all of it. But it hasn't addressed to this court's satisfaction, meaning the general language contained in the temporary injunction that's currently in place. It's the buffer zone contact language, but not specifically addressing to this court's satisfaction the posting of YouTube videos and or other social media posts and or other publications or documents, videos, photos, and the like that have been the cause of what is alleged and purports to be, from Ms. Preston's perspective, causing substantial emotional distress.
So you would add that to paragraph 1, because it mentions cyber stalking in paragraph 1.
I want to just be clear what that means.
Okay.
The language that I would propose, hang on, because I've done this before. That the respondent and/or anyone under his control, employed by him and/or in any way under his direction, including but not limited to any and all administrators of any form of social media, has the responsibility to assure that he does not, nor do they, in any form whatsoever, utilizing any media platform or conduit of information of the name, image, and/or likeness, and/or any information, data, photography, videos related to or pertaining to the petitioner and/or her minor child. It's really it's a stretch on the definition of cyber stalking.
Right, that's what I was
but
going to say, you're in court, it's almost like adopting the statute.
But I don't want there to be misunderstanding
Right.
about what our statute says
Yes.
and the specific circumstances of this case.
Yes, understood.
So I'm trying to narrowly tailor it and not infringe on his other rights to communication and/or speech, but as it relates to this person, this individual. And so I guess my question then is, if there's consensus on those restrictions, what will be left for us to discuss possibly will be the rescheduling in terms of timing. If there's disagreement about those conditions, it will impact whether or not there's a continuance at all, and/or whether or not this court needs to hear from you as to what alternative might need to be in place.
Okay,
But I want a clear understanding, and give me just a second to address Ms. Preston, who's
Sure.
without counsel. Ms. Preston, I'm not ignoring your needs here. I'm trying to balance what's going on here. So there's plenty of case decisions by appellate courts that allow respondents and you to have counsel of your choice. So that's like 2 layers: right to counsel of your choice, right
If
to
you can
meaningful
afford it.
representation, which includes a lawyer being represented with enough time and adequate opportunity to prepare. Mr. Shockett represents that he could do so. We haven't gotten to how much time he's going to need to do so. But the circumstance that's changed, and quite frankly does significantly change, that if we have to come back, is that you'll have the peace of mind and the protection of the temporary injunctive relief that, quite frankly, would be what Mr. Shockett says when he said you'd be winning in effect. It would track the language of what a final judgment would look like, but ultimately we'd still have to come back to determine if in fact there's a final judgment, and if so, what its terms are. They would be very similar to this in all likelihood. The real question for the final then would be for how long? Forever, for a year, for 3 years,
Right.
whatever.
And I understand all this, but what I know, I'm well aware of what they're doing. He is trying to hold us in contempt of court in Ohio.
Correct.
By using false
I know you said
lies.
you said that to
He's
me.
making them up,
Here's the
and he's
thing.
using them in that court, and we do not get to defend ourselves against it.
I know, but you
And so-
mentioned that to me on the 29th, and I'm not insensitive to that, but the
I
remedy.
brought proof to show just even
At that point.
one or the two things that he's using in Ohio, I can prove right now today are false.
So here's what's
Flat out.
relevant in this courtroom. When we go to hearing, if there's truth to what you just said, which is that he's trying to do these things in Ohio.
He wants me in jail
It
so that I
may-
can't be here.
The threat, okay, so the threat of falsely incarcerating you, I'm gonna put that in a broad light, most favorable to you of what you're saying,
Right,
may have relevance and materiality when it comes to this court deciding, has the behavior of Mr. Hales amounted to cyberstalking? But what you have to battle in Ohio about is whether the behavior you're describing amounts to a defense or not of violating the Ohio
right.
injunction, unless it's brought before this court to adjudicate on the merits whether there's a violation. I could adjudicate whether there's a violation of the Ohio injunction based on his allegations of your behavior,
Right.
but if he's in Ohio doing that, it's got to go to that magistrate or that judge.
I understand. He's just using the time of this thing to make that case, to try and make that happen. And that's what he's doing. And I do have the times, both times that Mr. Feather called me, of when he called me and offered me all the offers on this case. If
So-
he so wanted it over and done with,
He wanted over and done with at about 4:45 on
exactly.
November 29. There's no doubt
All
about
he has
that.
to do
I
is
just didn't
agree to
see how we
stop.
could accomplish that and provide due process for all the litigants.
Right.
You and Mr. Hales.
Right.
It would have short-circuited that and been an abomination
I
of due
understand.
process from this court's perspective. And I wasn't gonna, not on any case, certainly not in this one, conduct court in such a manner. I am considering granting this continuance based on the fact that there's now a change in circumstance, which is the temporary injunction in place, and what I'm suggesting is additional language. Mr. Shockett, you wish to be heard on the specifics of the language?
Yes, I don't object
any
to,
other matter.
I don't object to what you read gets put into the permanent as far, and we understand, they're not to post something about each other. That, the Ohio, this is reciprocal when you read
So-
Ohio and Florida. But I'm not gonna put it in our order, right? I understand.
It is and it isn't, okay? My understanding the other day is that, and again, I think it was Ms. Preston that brought it up, I'm not disagreeing with it, but I think she brought it up, Mr. Feather, I don't know if he was in the loop on it or not, but what was said is, and Mr. Hales would know, and you don't talk to me about it, but you could talk to your lawyer about it, is that in Ohio, there was a discussion about the possibility of doing a mutual injunction. Mr. Hales objected to it. I brought up, when that was mentioned here in court the other day, I said, well, everybody should be aware, I presume the lawyer, Mr. Feather was aware, there are no mutual injunctions in Florida. However, it could be, and this may be such a case, where the same two individuals can independently have an injunction against the other person, but the court has to look at this case and then look at that case independent. And so it's legally possible and permissible that both people can establish competent substantial evidence to establish that which they need in terms of the relief from the injunction.
Yeah, it talks about, I got the Ohio order, just interesting, but it's not
Okay.
going to be in ours. But this order includes any internet and/or electronic communications. They shall not cause or encourage any person to do any act prohibited by this order. So the best thing to calm things down is both parties just stop,
I'm not
posting.
doing anything, so
Okay.
please stop saying that.
That's the disputed
It's a
issue
lie.
of fact.
Okay,
It's
I
gonna be
understand.
decided at.
But I don't object to the language that you have suggested.
My suggestion is,
You can.
let me just check with my clerk here. Madam Clerk, I presume you could provide me an extended injunction of the temporary that's already in place. By the way, I may have been remiss, I may have just forgot. The record should reflect that at or about when we called court to order 1:15 or so, that at that time I wanted the record to reflect. Mr. Hales, you've been served with the temporary injunction, correct? That this court just entered 2 days
Right
ago?
here.
A sheriff gave me a packet of paper, I handed it off to my representation.
Okay,
So-
that is the temporary injunction Mr.
Right.
Shockett has.
I got it right here.
Okay, so what we're discussing now, Mr. Hales, is the court is inclined to grant your current counsel's request for continuance on the condition that there's now a temporary injunction. The clerk is going to provide me with, is a standard, extended temporary injunction to the date that we're going to talk about when we're going to come back for it. But I'm going to add the language that you or anyone under your control and/or employed by you and/or in any way under your direction, including but not limited to any and all administrators of any form of social media, has the responsibility to assure that you do not, and they do not, publish in any form whatsoever, utilizing any media platform or conduit of information of the name, image, and/or likeness, and/or any information, data, photography, videos related to or pertaining to the petitioner and/or her minor child. It's a long way of saying cyber stalking from this court's perspective, and it will be similar in nature to the peace of mind you're entitled to from the Ohio court, as I understand it in my review of that judgment. It'll be
Does that
temporary, it'll extend through the date we come back, and at that point, when the court begins the proceedings, I'm gonna go to Ms. Preston and say, do you wish to present your case for it to be longer than, which is to get a final judgment? If she wishes to go forward, we'll go forward and we'll hear the case.
Okay,
Does
just,
that
he has a
cover
quick
John
question. May I
Cook?
just confer with him for a second?
Sure,
Okay.
sure.
Does that cover John Cook? It should. I wrote him on the first paper.
I'm sorry?
John Cook, my ex-husband who lives on my property, he was listed on the first order.
So, Mr. Cook, it does not have the protection of an extended injunction and would need to file pleading.
He lives on my property. We live in the same building, the same home.
I understand that, but I don't have a pleading,
I think it's going to be fine.
nor,
It should have
and
been
as a
on the
result,
very
no
first
jurisdiction
one.
over Mr. Cook.
It wasn't, it should have been covered like he put Miss Grizz on his, I put John and the baby on mine. It should have been covered for all of us on the initial one. It asks anyone else to be covered under this, and I put John Cook and Harley Grace Preston.
Well, this temporary is gonna protect the child, but not Mr. Cook, who is an adult.
All right, I'll have,
And it's
And Judge,
not,
one more clarification.
it's not filed on his behalf, ma'am, it was filed by you, but not on his behalf.
right, I'll have him file one immediately.
Your Honor, one last point, it's very minor, and I appreciate this. They live right across the street from each other, so this 500 feet.
No, we don't.
He has to cross, ma'am, I didn't interrupt you. I
I'm
appreciate you
sorry.
interrupting me. He's got to at some point drive on the road which is opposite her house to get to his house. And I think that's less than 500 feet. So can we carve out something, when entering his home, he's allowed to, come closer than 500 feet, like maybe put it 100 feet or something like that?
Your Honor, there's two different ends of our road. One road goes out by his house, one road goes out by my house. So there's two different exits. We can agree, I will
Hang
go
on,
this
hang
way,
on,
he
hang
can
on,
go
hang
that
on,
way.
hang on. Ms. Preston, if you can raise your right hand.
I'm
You
sorry.
solemnly swear or affirm the testimony after giving this cause will be the truth, whole truth, and nothing but the truth.
Yes,
Are you in fact
Let me
saying
God.
to the court that Mr. Hales can go to his house and from his house without passing your house?
yes.
Okay, hang on, let me talk to Mr. Hales. Mr. Hales, are you disputing that? Do you have to go by her house to get to your house or to leave your house?
I do not have to. There is another way to go out on the main highway of Route 19. I own 75 acres. My main ranch is 70 acres. I also own the old ARC building, the schoolhouse. So home is the 70-acre ranch. They intentionally stalked us to Otter Creek, bought property across the street from us. I have to go through North Otter Creek to get to the schoolhouse where I'm running my business with my employee. I could go all the way around out on Route 19, which is high accident area there in Otter Creek. I'd rather not put myself in danger, rather not put my loved one in danger or my employees in danger. I would like to be able to drive down my road to get back and forth to where I need to be.
What would be the difference in mileage if you had to go out on the main road?
It's probably, I'm gonna guess, maybe a mile going around in the circle on the main highway versus non-main highway.
I don't think there's a need, there's not good cause or justifiable reason to allow even the ingress and egress. It just doesn't make sense. It's creating and it's perpetuating a problem while this is going on. There's just no sense in running that risk. You're saying the risk or the downside of this court not carving out that exception is you got to drive a little farther, which I presume to get out of your neighborhood, you're going to drive on that road at some point, and I hope you're a safe driver and pay attention. And so it's a little bit of an inconvenience, but so is everything pertaining to these cases and multiple cases. I'm not insensitive to it, but it's like, justice and the path to get to justice is inconvenient.
It's the same for me, Your Honor. I have to be inconvenienced to
understand.
go all the way around to go to Chiefland. I have to go out all the way, go to the stoplight, when I could just shoot out in front of
Right
him.
now, I'm entering an order about
Yeah.
Mr. Hales, and I want to make sure that he has a way to get to and from his premises,
And
even
I
if
won't
it's a
drive
little
by
more
him either.
inconvenient.
1.66.
I won't drive by him either.
Where's the road?
This is the road.
I'm gonna-
You either go there on
should
the main
have said
highway
that.
to get over to the school.
Yeah.
I don't know if
Or
I can
go
print
here,
right there.
And I don't get in an
I think
accident.
I could take a break and do it. Does this print over there?
So as of right
I'm
now,
gonna-
I
I
can't
just
even
sent it
go
to
on my
myself.
property.
Wait a minute. Where's the entrance here? You go this way.
This is her.
Where's your entrance?
My entrance is 539 feet from
From-
her entrance.
Then
This
you-
is all my property.
Then you can, here you're safe. You can enter here. Okay? And you can put a camera here. Motion sensing camera, 24/7. That's what I want. I was going to tell you to do that. We're good, Judge. We just realized he can still do it within, it's more than 500 feet away to get into his property, so I withdraw that request.
Okay.
The properties are not, but the way his entrance is over 500 feet, even in the shortcut, even using the shortcut. So
Okay.
he'll be okay.
So let me do this.
When it sends an alert, is any movement, you know what I mean? It has a date and time stamp, yeah.
How am I gonna put it there? I have somebody else put it up. I can't-
Take a brief recess. I can go to my computer and
Have someone put it there.
print out an addendum, so it'll be the extended temporary injunction, and under the appropriate section, Madam Clerk, I don't know which one, when there's another.
Yeah, it asks for an additional order necessary to protect petitioner from stalking us, but please be attached to it.
Okay. I'll just
500 feet from her house.
type up that language that I just read in as the addendum.
It's all forest.
Or whatever,
You don't
just,
see anything.
just put it where you can see it. Code or leave.
We okay?
Car, get your car coming out too.
We good?
We're good.
All right, so let's just stand at ease.
Thank you,
Give me
Jim.
5 minutes.
Okay.
We'll be at ease.
Is that all right if I run out and change in my daughter's diaper with my ex-husband, please?
Yeah, we're taking a break here.
Okay.
If you need a little more 5, just let my bailiff know. All right, we're back on record.
Yeah.
This is a continuation of Hales and Preston. This case is 23 DR 416. All right, so we've prepared the extended injunction for protection against stalking. It includes reference to an addendum, which the court reduced to writing. That'll become part of the directive and the order of this court. The injunction and the injunctive relief set forth in the order will remain in place through January 4 at 9:00 a.m. when we reconvene in this courthouse and in this courtroom for the resolution of the rest of the matters in terms of presentation of evidence of that which began on November 29. The respondent's motion to continue, filed 12/5/23, is granted. The continuance will be to the January 4th date at 9:00 a.m. So, Mr. Hales, I just want you, I'm not expecting that you'll violate the terms of this, but you're entitled to be aware of the fact that a violation of the terms of the injunction, including the language that's contained in the addendum that I've already read to you, in Florida, it goes one of two ways. Initially, it'll go to the Office of the State Attorney. They could prosecute it as a first-degree misdemeanor, which is punishable by up to a year in jail. If they do not pursue it, then it gets remanded back to this court to pursue, if at all, as a matter of contempt. Potentially, you'd be facing up to 6 months incarceration. You understand a violation could result in either of those. You understand that?
Yes.
Okay. Do you have any questions for the court?
No, sir.
Okay, and then the second part of it, again, I expect you'll be here, but you understand it's your obligation to be back in court on January 4 here in Levy County.
Yes.
All right, I'll see you then. Counsel, anything further on your client's behalf?
Thank you, Judge.
Ms. Preston, anything further from you or any additional questions or anything?
No.
Okay, all right, we'll stand adjourned. I'll see you all, if not before, maybe Mr. Shockett in the new year.
All right, Happy New Year.
Good luck to you all. I'll see you then.
I think I'm going to see you tomorrow, too.
Am I, okay?
You going to the Circuit?